Good afternoon. It's June 15th. This is To My Liberal Friends. We need to find a new way to tax you, so we will create a new one. That's the mantra of the progressive left, and they will stop at nothing trying to raise taxes on anyone they can determine to be wealthy. Of course, they should beware what they do because it might come back to bite them. In 1913, the 16th Amendment to the Constitution was ratified, and it granted Congress the authority to issue an income tax without having to determine it on population. The exact text of the amendment is as follows, quote, "The Congress shall have power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census enumeration," end quote. Now that's kind of vague, and in the Constitution's original writing, the taxing clause in Article 1 grants Congress the general authority to, quote, "lay and collect taxes, duties, imports, and excises." For direct taxes, Article 1 demands that they must be collected based on the population of the states. Therefore, an income tax was used there before it was established. The majority of funds given to the federal government derived from tariffs on domestic and international goods. The end of the 19th century saw the beginning of the progressive era, a time of period in which political and social reforms centered on industry, voting, immigration, and several other issues of the time. Levying a federal income tax became a key goal for many progressive groups, the key argument being that it was fair for wealthy individuals to pay for the taxes and tariffs that had been largely, in their opinion, being taxed from the middle class and poor in society. Congress passed in 1894, the Wilson-Gorman Tariff Act, which contains an income tax provision of 2% on incomes of over $4,000, and that's equivalent to $135,000 in today's dollars. Supporters of this new income tax argued that it was not specifically, quote, a direct tax which would require to be apportioned among the states. Two previous Supreme Court decisions supported this thesis, but the 5-4 decision in 1895's Pollock versus Farmers Loan and Trust Company ruled that the income tax in the act was, in fact, a direct tax. The core argument was that the income tax in the act was sourced from deriving income from an individual's property. Based on this, the court asserted that direct taxes included any sort of income tax on rents, dividends, and interest, therefore making them legally required to be apportioned among the states. Well, we have a progressive income tax system in this country where your marginal rate increases with the amount of your taxable income. But progressives have long chafed that, in their opinion, the wealthy should pay more, and you hear it over and over from them that people should pay their fair share. Now, they never mention what they think is their fair share, nor do they mention that the top earners pay, meaning the top 10%, pay almost 80-some% of the federal income taxes. They ignore these facts because it does not fit their narrative of demanding that the wealthy should pay more. The door has now been opened for the progressives in Congress to try and impose a wealth tax on the American people. In the 2017 tax bill, Congress put in a mandatory repatriation tax to tax shareholders of some corporations on their retained earnings, particularly those overseas. Its interpretation is a bit murky and now has come home to bite some Americans. The real test case comes from Charles and Kathleen Moore. They invested in a friend's venture to distribute farm equipment in rural India. The company reinvested the earnings to grow the company, and the Moores did not receive any cash dividend or payout. But under the 2017 bill, they were sent a tax bill for just over $14,000. Well, the Moores sued the IRS and sought a refund on the grounds the tax is an unconstitutional levy on income. They lost in federal district court, and the Ninth Circuit, long considered the most liberal of the appellate courts, refused to hear the case. But Judge Patrick Bumstead issued a hard-hitting dissent that called out the majority decision as contrary to, quote, ordinary meaning, history, and precedent. In Eisner versus Macomber in 1920, the Supreme Court held that a gain in an asset's value qualifies as income only if it is, quote, received or drawn by the recipient, that being the taxpayer, for his separate use, benefit, and disposal, end quote. That surely doesn't apply to the Moores. The High Court has reinforced that ruling in more recent cases. And as Judge Bumstead writes, the Ninth Circuit is the first court in the United States to depart from the Supreme Court definition of income for tax purposes. He rightly notes that the ruling opens the door to, quote, expansion of the federal taxing power beyond the limits of the Constitution, including taxes on all sorts of wealth and property, end quote. And that has never been the subject of the federal income tax. The Moores have appealed to the Supreme Court, and hopefully they will take the case and put a stop to this. Already, Ron Wyden, Democrat of Oregon, has floated the idea of a wealth tax, and he's chairman of the Senate Finance Committee. Before you nod your head in agreement with him, consider the facts. You purchase some stocks that are valued at $100,000, and during the year they rise in value to $180,000. You think there's still room for growth, so you hold on to the stock. But the IRS could then look at that and say, hey, you have an $80,000 gain, and that's in fact taxable income, even though you don't have the money in your pocket. Making it even more succinct, you buy a home for $350,000, and after 2 years, the home is now valued at $450,000. Now that's an unrealized gain, and the IRS could add this to your income and say the gain of $100,000 is taxable. But then the next year, the stock you bought dropped back to the original price of $100,000, or the value of the home dropped due to market conditions back to, say, $400,000. Do you get a refund since you paid the taxes? I don't think so. This is the problem with trying to tax unrealized gains. As the Supreme Court held in Eisner v. Macomber in 1920, a gain is an asset that value qualifies as income only if it's received or drawn by the recipient for a separate use, benefit, and disposal, end quote. In the Moores case, in the two hypothetical cases I cited, the funds were never received for any other use or benefit. Now, progressives will look to tax you in any way they can, and it's now up to the Supreme Court to take care of this case and put an end to this foolishness once and for all. It's meant to my liberal friends. Thanks for listening.